Mr. Parker, you have 15 minutes this morning, sir? Did you wish to reserve some time in rebuttal?
Yes, Your Honor. I'd like to say 5 minutes.
5 minutes. All right. Again, since we don't have lights there, if you start getting close to your time, I'll just kind of, I will keep your time, but I will break in if I have to. All right?
Your Honor, I just wanted to clarify, Attorney David Lang will be arguing for the
Okay. Thank you, Mr. Lang. Well, then, thank you. All right. All right, Mr. Parker, then you may proceed, sir.
Thank you, Your Honor. In 2001, appellant Rick Carlson began attending Hamilton County delinquent land auctions and purchasing homes in the Fairmount area of Cincinnati at nominal prices with the intention of fixing them up and renting or reselling them. He also purchased properties through his single-member LLC, Tuscan Hillside Development, and he encouraged his children to purchase properties for themselves. His reasoning for involving his children was that purchasing such properties was an investment for their future and that he could work together with them to fix up and repair these properties, recondition them, and thereby provide an opportunity for familial bonding and pass on some skills that he had obtained in a lifetime as working as a carpenter. At auctions throughout the period from 2001 to 2016, Hamilton County permitted Rick Carlson to purchase a total of roughly 130 properties. It also permitted the purchase of another 80 properties between his LLC and his children during the same period. Rick Carlson and his family were well known to the administrators of the county land sales, and it's hard to imagine how they couldn't have been given how often they showed up and bought properties. But the county, presumably glad to simply have the vacant lots off its books, made no serious attempts to stop these purchases, nor apparently did the city urge them to do so.
Well, Mr. Parker, just let me ask this question. It appears that there's already been an entry of satisfaction of judgment that has been placed in the record. Doesn't that make all of this moot?
No, Your Honor. I believe that was only with respect to one appellant. And I'm not certain that it even satisfied everything on that one.
Well, it was with regard to Mr. Carlson, I believe. Is that correct?
Yes, Your Honor.
Okay. So,
actually, I thought it was with regard to Daisy Carlson.
yeah, I have the entry of satisfaction here, and it's satisfaction of judgment and release of lien. Now comes City of Cincinnati, et cetera, et cetera. Petitioner counter-defendant Rick Carlson is satisfied, and the certificate of judgment is 1820531. So you're saying, despite the fact Mr. Carlson appears to have satisfied the judgment, this matter is not moot concerning him?
That's correct, Your Honor. I would be perfectly happy to accept a decision, and my clients would be perfectly happy to accept a decision saying that it was moot with respect to him because he satisfied the judgment. However, it's our understanding that that was just a tool to make sure that a lien was removed and properly reapplied in the right order on a piece of property. I don't think the city is contending that he has satisfied the judgment. David is free to correct me if I'm wrong on that.
Okay.
Yeah. All right. According to the city, do you mind if I continue? I apologize, Your Honor.
Yes, thank you.
Okay. According to the city, during this entire period, the Carlsons engaged in a consistent pattern of non-compliance with city ordinances regarding fees for vacant building maintenance licenses, demolition costs, water supply, the maintenance of lawns, and the like. But despite this purported 16-year pattern of non-compliance and the staggering sums the city is now demanding, the city made no attempt at any point to inform the Carlsons of the magnitude of the debts that they were purportedly accumulating, and similarly made no attempt to collect those debts. That attempt only came in 2017 when appellant Rick Carlson for the first time attempted to prevent the city from demolishing one of his properties by filing suit to enjoin that demolition. The city then filed counterclaims against Rick Carlson and third-party claims against his LLC and his children. The Carlsons are, to put it mildly, unsophisticated. The notices they received from the city regarding most of these purported debts did not provide the totals of the amounts owed. They often left it entirely to the Carlsons to calculate the amounts they owed, even with respect to a single notice. And the Carlsons were ill-equipped to understand the relevant ordinances and perform the necessary calculations. Those calculations, it should be noted, have repeatedly proven impossible for the city itself to carry out accurately. The Carlsons were therefore shocked by the magnitude of the city's counterclaims and demanded that the city support the amounts it sought using competent evidence. The city has singularly failed to do this, and the trial court's decision to grant summary judgment therefore cannot stand. Appellants have presented 4 assignments of error. First, that the trial court erred by granting summary judgment with respect to the VBML fees specifically that are purportedly owed by the appellants because there was an absence of competent evidence supporting the amount demanded by the city, and because the trial court denied appellant's motion for leave to file a surreply to point out the incompetency of the city's new unsworn evidence presented in its reply brief. The second assignment of error, which the city does not contest, is that the trial court erred by granting summary judgment in an amount unsupported by its own calculations. The third assignment of error is that the trial court erred by granting summary judgment against appellant Jeremiah Carlson with respect to a single VBML fee that was out of statute at the time that the city filed its third-party claims. And the fourth assignment of error is that the trial court erred by accepting the city's interpretation of the VBML fee ordinance, which interpretation renders the final sentence of that ordinance entirely inoperative. Specific to the first assignment of error, in its motion for summary judgment, the city sought $285,000 in purportedly unpaid VBML fees. VBML stands for Vacant Building Maintenance License, by the way. It's the system the city uses to essentially penalize the ownership of vacant buildings in order to incentivize development of those buildings. The city supported that $285,000 figure with only a single affidavit in which its affiant, Edward Cunningham, stated that none of the Carlsons had ever obtained VBML licenses or paid VBML fees for a set of listed properties, including specifically the one located at 1862 Knox Street. And that affidavit further stated that the amount of delinquent fees was $137,800. When appellants pointed out this unexplained discrepancy, $285,000 versus $137,000, in their response, the city chose to attach to its reply in support of its motion for summary judgment a set of new calculations, asserting that the amount of delinquent fees owed was actually $209,000, as in almost exactly between the two other figures. That new set of calculations was not supported by any sworn evidence, but rather only by a statement that the city could not explain its earlier errors and that counsel for the city avowed that the new calculations were correct. The trial court, of course, later found that the new calculation was also incorrect because it failed to account for Rick Carlson's payment of a VBML fee for the lot at 1862 Knox, which was one of the properties that the city's affiant swore that the Carlsons had never paid a VBML fee for. As a result, the trial court nevertheless granted summary judgment based entirely on the unsworn calculations provided by the city pursuant to the statement by the city's attorney that they avowed that the calculations were correct. This is essentially summary judgment by ambush. The trial court also denied appellant's attempt to file a surreply to point out that the unsworn statement by the city's attorney was not competent evidence. Civil Rule 56 does not permit a party to obtain summary judgment by ambush, whereby the moving party introduces new arguments and new evidence for the first time in a reply brief. It's from HSBC Bank USA v. Byrne Jr. It's a 9th District Appellate Court case, 2012 Ohio 1386. A party is barred from raising new arguments and offering new evidence for the first time in a reply. That's in refuel adjustments clauses for Columbus South Power Company, 140 Ohio State 3D 352. If a new argument is raised or new evidence is offered in a reply, the proper procedure is to strike the reply, or alternatively, to allow the opposing party to file a surreply. That's from Baker v. Coast to Coast Manpower LLC, 2012 Ohio 2840. That's from the 3rd District Court of Appeals. Nonetheless, the trial court refused to allow a surreply to this new evidence presenting a new calculation, and the trial court granted summary judgment. This was clear error. With respect to the second assignment of error, the city agrees.
Mr. Parker, let me ask you a question about what you're calling new evidence. I know that the Cunningham affidavit referred to, looks like Exhibit D in the city's counterclaim against your clients, which listed the dates that those buildings were vacated. The court also had in front of it the VBML license fees, and also was aware of the 6-year statute of limitations. So with that information in front of the court, wouldn't the court have been able to calculate the delinquent VBML fees if it so desired, and maybe it did so? You
In theory,
understand
Your
what I'm
Honor.
saying? I mean, he had the information in front of the court, and it was presented in summary form by the city to alleviate the court having to go through those calculations. Do you have a response to that?
Well, yes, Your Honor, there are two problems with that. In theory, you're absolutely correct, but there are two problems with that, in fact. The first is that there was no competent evidence, or at least there was significant question with regard to the evidence, and I would say there was no incompetent evidence or competent evidence showing that the appellants had not paid these VBML fees for all of the lots in question, because after all, the affiant swore the appellants had not paid a VBML fee for 1862 Knox, and the trial court ended up finding that they in fact had paid a VBML fee for 1862 Knox. There's no way that we can be certain that these cities affiant actually went through and looked and saw whether or not the VBML fees had been paid for all of these lots.
Was it
That's,
accurate?
that goes,
Let me ask you this, and was it accurate with regard to the order, the VBML orders with respect to all the other properties listed?
Your Honor, plaintiffs can't be certain of that. Or sorry, not plaintiffs, I apologize. Appellants can't be certain of that, and it's the city's burden to demonstrate that. Given that the only affidavit they provided was incorrect on 2 counts, it seems as if there's no competent evidence available to support the idea that the other lots did not have VBML fees paid for them.
Okay. All right.
In addition, Your Honor, it seems obvious that the trial court did rely on the unsworn calculations provided by the appellee, the city of Cincinnati. After all, the numbers that it gave exactly matched up with the city's numbers, even to the point that when filing a corrected judgment, the trial court took the number from the city's reply brief rather than the number that would have been correct under its own theory of correction, where it agreed that $3,500 should have been discounted. It still apparently copied and pasted over the amount from the city's reply brief. The amount exactly matches up with the city's reply brief. That amount, once again, the city can't explain how it had an error previously. There's no reason to believe it got it correct this time.
Mr. Parker, you are at your time if you want to save your rebuttal time, sir.
Can I have 2 more minutes, Your Honor?
That's fine.
Thank you, Your Honor. Moving on to the third assignment of error, this one is fairly simple. The VBML fee became due on July 27th, 2011. The city's argument that it became due only on the last date of the year for which it was important would, if you applied that to say a lease, it would say that the lease's statute of limitations begins to run only at the end of the lease and not when the person first stops paying or at the date of the contract. It's a circular argument that doesn't make a lot of sense. Fourth assignment of error, the text of the ordinance setting out the VBML structure is absolutely clear. The last sentence is an exception to everything that goes before it, and it states that for the first year of ownership of a property, an owner only has to pay $900. Thereafter, the graduated scale kicks in. The trial court found that the Carlsons were liable for VBML fees that have been escalated. Sorry, the escalated VBML fees for more than 1 year of vacancy, even in the first year in which they own several of these properties. Thank you, Your Honors.
All right, thank you, counsel. Mr. Lang.
May it please the court. This case isn't about the notice that the Carls received, although that is what they argued before the trial court. This is fundamentally about how do you calculate the liabilities, and are any of them subject to the statute of limitations, or were they in some way miscalculated under the statute? So the biggest contention seems to be under assignment of error number 1. So I'm going to go there first. And I want to be clear, at this point, they aren't challenging their liability for the more than $69,000 for unpaid water bills, civil fines, a lot of abatement costs, or emergency barricades of their many blighted properties throughout the Fairmont community. This is solely about the VBML fees and solely about the calculation of those. So first, I believe Mr. Parker is conceding that we do not know how the trial court came to the number that it arrived at. Now, he's saying it's obvious because it matches the number that the city provided. But as Your Honor, Judge Winkler pointed out, the court could calculate that based on Exhibit D attached to the counterclaims. And there you just need to note the date that the property was ordered vacant, in addition to the date that they acquired the ownership, both of which are contained within that exhibit. And then you can just apply the math that comes from the VBML statute to it. That's how you get to that number. And the reason that the trial court's number matches the number that the city had attached to its reply brief is because that's the nature of math. When you do the math right, the answers match up. So if for some reason there was a discrepancy between that and the trial court, that would show that the trial court had relied on something. But because they came to the same conclusion, there's no evidence that the court relied on anything other than that. Moreover, to the extent that the trial court did err, that error would be harmless error. Mr. Parker has presented no evidence or no argument that the calculation is in any way, the calculation of the damages is in any way wrong. So that means that if there was an error, as long as that number's right, there's no, it does not impact the substantial rights of the parties. And so any error, if there were any, would be harmless. So in sum, the trial court got the right answer by relying upon the evidence it had before it attached to the city's counterclaim and certified by the Cunningham affidavit. Moving to assignment of error number 2, we agree that the trial court intended to credit the $3,500 payment, but it just failed to do so in the final entry. Assignment of error 3, each and every day that a property is subject to the VBML ordinance, the owner has an obligation to have a VBML for that time period. And so whether it's day 1 or day 365, they have to get that. And so it makes sense to calculate that from each of those days to see whether it fits within the statute of limitations. If one of those days fits within it, so the 365th, then that is a valid claim. And here that was the case. Moreover, I would note that the criminal penalty, this is also criminally punishable if you don't abide by an order of the Director of Buildings and Inspections. Each day is attached, separate criminal liability attaches for that. So it wouldn't make sense to apply the civil remedy differently than how the criminal remedy applies. Finally, assignment of error number 4. The Carlsons waived this argument because they did not raise this before the trial court until the motion for reconsideration, which is not proper. Moreover, in their brief, they didn't cite to where in the record they had raised this issue, and they only fleshed this out, and even then, without a specific cite to the record as to where that they had raised this issue before the trial court. But assuming the court finds it's not waived, the whole point of statutory construction is to give effect to the intent of the legislature. To the extent that there's ambiguity in the language, and there is no ambiguity, the very first sentence of the vacant building maintenance license ordinance is that the liability is going to attach based on the duration of time that the building has been ordered vacant. And moreover, to the extent that there is an exception, and I believe Mr. Parker said that exception applies to everything that came before it, that exception 100% entirely swallows the rule. The whole idea of setting out that scheme is so that properties that have been ordered vacant for a longer period of time have an incentive to be returned to productive use, to recover the city's expenses, and to protect the public from the harm of vacant buildings. And if we allow, such as the Carlsons have done frequently, to transfer properties between themselves, between LLCs, we would never be able to recoup the actual cost of the city's expenses, and that would undermine the city's ability to protect the public from the harm of vacant buildings. So in sum, we believe that the trial court properly found, it's our contention that the trial court properly applied the VBML ordinance to the facts before it. So in sum, Your Honors, the city would ask that the trial court be affirmed on all accounts. To the extent necessary, if you feel it's necessary, the case should be remanded solely for the purpose of assignment of error 2 to correct the $3,500 payment that the Carlsons have made. And if the court has no questions, I would, that's all I have.
I do have a question for you, Mr. Lang.
Yes, sir.
It concerns the that satisfaction of judgment and release of a lien. I know I asked Mr. Parker about it. Does it only apply to one property? Does it apply to the entire judgment? I haven't looked at the certificate of judgment 18-20531. Does that make sense? Or is it, my thought is if the city put on an entry of satisfaction, you may have a double the time collecting it from Mr. Carlson, if you haven't already done so.
Yeah, sure. I believe Mr. Parker described it accurately. I believe it just applied to the one property.
Which one?
I believe it was the Knox proper.
Yeah.
Apologize, Your Honor. I don't have that at my fingertips.
It may be in the certificate of judgment. I can look at that. And all right, now my second question too concerns that the VBML ordinance, was there a prior VBML ordinance prior to 2006, or is it a fairly new licensing structure?
My recollection from looking at it is there was a VBML ordinance that went back at least to 1996. I don't have it. I don't have that in front of me, but I can pull that up on municipal code real quick and see, because that has the history.
No, and I can look too. I just I didn't know if it was a brand new ordinance or not.
Okay.
Okay.
No other questions. The city rests.
Thank you, counsel. Mr. Parker, sir, you still have, you have 3 minutes in rebuttal, sir.
Your Honor. First, with respect to the first assignment of error and the question of whether or not the court performed independent calculations, the statute of limitations issue with respect to 2516 Liddell demonstrates that the court did not perform an independent analysis, because had it done so, it would have noticed that property's VBML fee for the year 2011 was out of statute. The city's argument that the statute of limitations cannot begin running until after something is no longer due, it is simply nonsensical. That doesn't it doesn't fit with how anything else works, how contract law works, or how a lease would work. If the statute of limitations can't start running until after it's no longer due, then there's nothing for the statute of limitations to affect, because it's no longer due. It simply isn't an internally consistent argument. Moving on to the fourth assignment of error. The city first argues that this was waived. It wasn't. It was raised in in appellant's motion for reconsideration in federal courts. There's no direct ruling on this in Ohio, but federal courts analyzing the closely analogous Rule 59E have repeatedly held that a new argument raised in a motion for reconsideration is preserved for appeal if the court addresses the merits of the argument. The reason for this is fairly obvious. Otherwise, a district court could create new law on a motion for reconsideration, and there would be no opportunity for it to be reviewed whatsoever. And the parties are bound by that law. The parties would also be bound by res judicata with respect to that in other cases. All sorts of reasons why, if the court rules on the merits, it is preserved for appeal. The appellant cited to where the district court, or the trial court, sorry, that the appellant cited to where the trial court specifically ruled on the merits in their reply brief, and as a result, it's in the record for this court, wasn't waived. Moving on to the question of the statutory interpretation, they claim that the whole point of statutory construction is to give effect to the intent of the legislature. That is only true. All right, sorry. It's a relevant quote here from the Ohio Supreme Court. From the U.S. Supreme Court. That is, the law is settled that however inclusive may be, I apologize, I've misplaced the case. Regardless, the point is that the purpose of statutory interpretation, here it is. Okay, it's from the Ohio Supreme Court. The question is not so much what the legislator intended to enact as what did it mean by what it did enact. That's from Singleff v. Weaver, 66 Ohio State 621. The question of what the legislature intended only becomes an issue if the statute is itself unclear. The statute here is not unclear. The argument that the city raises with respect to the ability to transfer properties back and forth, that does not render the statute unclear, so it's irrelevant. But more importantly, even if the court finds that it's absurd, which it would not be because it is not in a genuine sense absurd, it is not something that the legislature could not possibly have intended. But even were that the case, the proper remedy would be to do the least violence to the statute possible, and rule that an initial application for a license fee means an application that is not a sham application by a new entity that is linked in ownership or otherwise linked to the previous owner. The exception, therefore, under that interpretation would not swallow the rule, and it would give effect to every part of the statute. Unless your honors have any other questions, I will rest.
All right. Thank you, counsel. The case is now submitted. Thank you for your arguments this morning. We will review the record and issue a timely opinion. Thank you.
Thank you.